Hi, my name is Emily, and I am here with Maya Murphy's attorney, Lauren McDonald. She will be answering some questions about education law in Connecticut, specifically the suspension of a student. So, Attorney McDonald, my child is facing suspension from school in Connecticut. What are my child's legal rights? Can they suspend him or her without a formal hearing? And can I appeal that school's decision?
Hi, Emily. Thank you. That is some great questions, and I'm happy to answer them for you. In Connecticut, a suspension is an exclusion from school services for no more than 10 days. And a student can be suspended for violating public policy, a publicized policy, which is usually included within a student handbook or a code of conduct. A student can also be suspended for endangering others or property, and also being a substantial disruption to the educational process. It's important to know that a student can be suspended for conduct that does not occur at school. So that means it can be conduct that occurs off of school grounds or on the internet. Pursuant to Connecticut law, all of suspensions should be in school as opposed to out of school suspensions unless two factors are met. The first factor would be if, due to the student's disciplinary record, it's appropriate to have the suspension out of school, as in the student has had other in-school suspensions and the discipline is not working, essentially. A student can also serve an out-of-school suspension if having the student in school would cause a serious disruption to the educational process or endanger other students. So those are the two factors where it can be out of school as opposed to in school. Now, before a student is suspended in Connecticut, they are afforded the right to an informal hearing. This usually means a meeting with the principal or assistant principal and the student so that the student can explain their side of the story, respond to the charges that they've are being alleged by the administration. It's not a formal hearing like what occurs during an expulsion hearing, in which you have the right to cross-examine witnesses, present evidence, and submit your own testimony. It's not that type of formal procedure. And for your purposes, an expulsion is an exclusion from school services for more than 10 days. So that's when a student is afforded those types of full hearing rights. But students and parents also have the right to have notice of the proposed suspension. So after the informal hearing, if the school administration still decides to suspend your student, then the parents are supposed to be notified within 24 hours of the proposed suspension and of the alleged charges. Parents do not have a formal right to appeal the school's decision regarding the suspension, but it may be important to speak with an attorney because you want to make sure that the student was afforded their due process rights in regards to the informal hearing, and also that they were not targeted or discriminated in any type of manner regarding the suspension. So oftentimes when parents retain me to assist them with disputing a suspension or seeing if a suspension can be reduced, waived, or some other type of program can be entered into with the school, I usually request an in-person meeting or a phone or video conference with the school so that I can sit down and speak with the principal about the facts and circumstances of the student's case and if there's any mitigating circumstances there. It may encompass procedural and substantive legal issues that I may raise with the principal. It's important to know also that in Connecticut, pursuant to statute, the school administration can waive or shorten a suspension if it's the student's first time being suspended and that they've never been expelled before. As long as the student fulfills an administrative specified program and meets the conditions that the administration asks them to do. This could be, for example, if a student is suspended due to harassing another student, the school may say, will expunge this suspension and waive it as if you've never been suspended, as long as you complete this type of sensitivity training that we're going to require you to do and write an essay about what you learned from the training and about the incident as a whole. Usually meetings can be helpful to see if that can be something that's on the table to ensure that the student is not prejudiced by some type of suspension. My particular approach to a suspension really does matter about the student's facts and circumstances of the case. So I'd be happy to discuss your student's suspension or any questions you may have. So feel free to give me a call.